Hey folks, George here again. In today's philosophy of law discussion, we're going to examine the question, what is law? What is a law, and how do we know what it is? David Adams gives us a very famous case to analyze two different sides of this issue. The famous case being the Nuremberg Trials in 1945 following World War II, right? Really quick, at the end of World War II, there were trials that were set up to prosecute the individual Nazis, the worst of the worst, let's say, who persecuted certain crimes. There were three new crimes that the prosecution charged the Nazis with. The first being crimes against peace, the second being war crimes, and the third being crimes against humanity. Now, these were brand new crimes. Everybody, brand new charges, brand new laws. Everybody agrees that these were brand new laws, that before these trials were not written down anywhere. They were not written down anywhere, and that's where this gets to be a controversial sort of case. How do we try Nazis for crimes that weren't written down prior? Just so that we could really clarify and understand the crimes that they were being charged with. Let's see what exactly crimes against peace means. Crimes against peace, namely planning, preparation, initiation, or waging war of aggression, or a war in violation of international treaties, agreements, or assurances, or participation in common plan or conspiracy for the accomplishment of the foregoing. That's crimes against peace. War crimes now. War crimes are namely violations of the laws or customs of war. Such violations shall include murder, ill treatment or deportation to slave labor, or for any other purpose of civilian population of or in occupied territory, murder or ill treatment of prisoners of war, wanton destruction of cities, towns, or villages, or devastation not justified by military necessity. And now let's read the last one, crimes against humanity. Namely, murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds, whether or not in violation of domestic law of the country where perpetrated. So we see, especially that last one, where we can really see this controversy that's going to emerge with these three brand new crimes that these Nazis are going to be charged with following World War II. By the way, they also held war crimes tribunals in Japan, the Tokyo tribunals. Those were able at least to claim, look, we did this in Nuremberg, so we could do this in Tokyo too. Whereas in Nuremberg, since they were the first, that's where the controversy arises. By the way, the Tokyo War Crimes Tribunals have a whole slew of other philosophical problems with them as well. I'm not going to get into them. Perhaps we could talk about that at another time, right? But the key problem here is, what is the status of such laws that are brand new? What are their legal basis? Were these valid laws that we could put on trial, that we could put defendants on trial for violating? Were these trials valid? Are these legal trials? Are these trials in the name of justice? Yes or no? Now, all of those questions can be answered yes or no. And I'm going to examine two thinkers here, both legal jurists. One, the prosecutor, an American prosecutor, Robert Jackson, who presented and argued for the justice of these Nuremberg tribunals. And on the other side of the table, we're going to have legal scholar and jurist Charles Wiesanski. Charles Wiesanski is against suggesting that these are legal trials, right? Here's other questions that these sorts of questions bring up. And these are questions that are even valid today. What is the status of an international law? Can there be an international law? Now, this is a question that still arises today whenever certain leaders from around the world are brought up on charges for violating international laws. They say that's not a valid law. What is this? Right? They might say, wait a second, isn't this just a tool of Western imperialism to tell us about a law that we don't even agree to? Yes, and very frequently, from an American perspective, dictators might be charged with such things. People who perpetrate such crimes might be charged with such things, and they'll say, I don't recognize the validity of this international tribunal. So even today, these are still controversial claims, right? Even in America, by the way, right? What does America recognize in terms of international laws? These are very complicated questions, but by asking these complicated questions about what makes laws binding, what makes international laws binding, we could take the same principles and apply them to domestic laws. What makes the laws in my own country, in my own community, binding over me, right? Is it that there's a government that says so? We'll examine this in a little while, in a future discussion, where we see that different thinkers have very different ideas about what a law is. And this is just a starting point. This is a nice starting point that David Adams presents to us by framing it within the Nuremberg Trials. Certainly this has come up even in America, right? Of prior President George W. Bush took as prisoner certain Taliban soldiers from Afghanistan in the war in Afghanistan and didn't give them certain habeas corpus rights. What is habeas corpus? Habeas corpus is the right to tell them that the law that they're charged with violating. You are being imprisoned for violating this law. Well, they just imprisoned these Taliban soldiers without letting them know any crimes that they actually committed, right? Isn't that a violation of international law? Well, we'll see one way or the other. I'm not sure. Again, these are very controversial questions, right? That both sides, I believe, do have very strong arguments, and we'll see which you might consider to be the more reasonable arguments from one side or the other. So the first discussion that we'll examine are the ideas of Robert Jackson. I said that Robert Jackson was the prosecutor at the Nuremberg Tribunal in 1945, and he gives this presentation to suggest why is this a legal proceeding? How are these charges? How is this trial the embodiment of law, right? He's really trying to say these are legal. This does fit into what we understand as legal. He starts, however, by acknowledging these are the first such tribunals in the history of humanity, right? So he does acknowledge that these laws are brand new, that these charges are brand new, and yet he is going to try to defend and explain how we can use brand new charges. Charles Wiesanski later on is going to suggest that such tribunals, such laws violate ex post facto principles, right? Saying that you can't, it's illegal, it's not legal, it's not following the rule of law to charge somebody on a law that wasn't previously written down, right? However, Robert Jackson, that we're going to examine first, is going to suggest that here's why these laws are nonetheless justified and are just and do follow the notions of rule of law. By the way, he does try to suggest, wait a second, this isn't about vengeance. Because if this were merely about vengeance, the Allied powers, America and the rest, could have just executed all of these people. Instead, Robert Jackson wants to remind us, we are putting them on trial. And by putting them on trial, we are trying to show them and the world that we are going through a proper legal proceeding. Argument that he suggests is these proceedings, these Nuremberg trial proceedings, are supported by the victor nations, the 4 victor nations, but also 17 other nations from around the world. Now, this is George stepping back and going, why is that relevant? Does that justify, I'm asking you, does the fact that there are many nations who support these tribunals, does that support the nature of these being rule of law and following the rule of law? Is that relevant, the fact that there is a large contingent of people who do support these laws? I'll leave that to you, but that is a question that comes up in my mind when I read Robert Jackson's arguments. Robert Jackson also suggests that we're not doing this for the benefit of them, the defendants. We are, however, doing it for the symbols that they will serve into the future. We are setting a precedent here in 1945 at Nuremberg. We're trying to set the precedent, he suggests, that these are the violations of laws, and we are trying to put in place and utilize this principle of stare decisis so that we can have this precedent for future people to know this is against the law. What the Nazis did is against the law. And furthermore, Robert Jackson reminds us, we should remember that these Nazis, that these war criminals who are on trial, violated the inalienable rights of so many people. I don't want to get into the history of World War II and the history of the Holocaust and the history of the evils that the Nazis did. If you need that refresher, please do that research elsewhere. I think it is unquestionable that the Nazi regime in Germany during World War II and in the lead up to World War II did terrible, terrible things. Here's a question, though, that I've got. How does that address the opponent's questions? This notion of inalienable rights. Is there such thing as inalienable rights, which means there are rights that I have in virtue of being a human being? Do I have such rights? Especially if they're not previously written down. Now, many people around the world do, and many people even in America do argue against such a notion. After all, isn't this just another tool of Western imperialism to talk about things like inalienable rights? And by the way, these inalienable rights are typically ideas that were generated in the West. How do we deal with that? That is a controversial question in and of itself. Robert Jackson just assumes it. What I, as a critical thinking philosopher, want to do is challenge, or at least consider and recognize the assumptions that Robert Jackson is making here. Robert Jackson also wants to remind us the nature of these Nuremberg trials. They are going to be fair trials. They're going to be temperate trials, reminding us again that, hey, the Allied forces could have just executed all of these people. Instead, they want to put them on trial in a fair and temperate venue, in a fair and temperate environment, instead of simply hanging them. Now, he does acknowledge that, by the way, we could have allowed them to be tried in their own country, by their own government in Germany after World War II. His argument against that, however, is that, well, by the way, there was this little thing called World War I that happened sometime earlier in their lifetimes, and the Germans did that sort of thing after World War I, but that didn't really work so effectively, right? And World War I simply segued rather nicely into World War II. And that's an argument or a reason that Jackson is going to make for saying, therefore, we Allied powers, we international powers, cannot leave it to Germany to do this themselves. We've already let them do this themselves after World War I. That didn't work out too good. The reason, he gives several reasons for suggesting why these Nuremberg trials must be handled this way. The first reason is we have to mete out justice and retribution. These people must be punished without question, but they must be punished in a manner that accords with the rules of justice and the rules of law. That means that these hearings will be dispassionate. They will be dispassionate hearings. The defendants, the Nazis, they'll be able to take the stands themselves and defend themselves. There will be a presumption of innocence. I hope you've heard presumed innocent until proven guilty. Robert Jackson suggests that these Nazi defendants will be presumed innocent until proven guilty. There were, by the way, previous treaties and laws that Germany was party to, and these trials are in place to say and illustrate how Germany violated those treaties and laws, their own laws even, right? Furthermore, the importance of these trials is to show that even leaders in the Nazi Party are susceptible to the rule of law. Nobody is above the law. Now, that is a principle that's been in the American news in a lot lately, hasn't it? That certain people might consider themselves above the law or not. I'm not going to discuss those issues right now, but we can see here in these arguments what Jackson thinks, what is law? What is this thing called law? Well, it's dispassionate hearings. Defendants are able to give their own testimony and defend themselves. Defendants are given a presumption of innocent until proven guilty, right? Defendants have to be charged with previous rules. Oh, we'll see how Robert Jackson finesses that a little bit. Now, Robert Jackson recognizes that there are problems that Wizanski, for example, is going to bring up and raise about these trials, about these hearings. And he addresses those challenges, and he addresses the controversy. The first one is, the first way he responds to these controversial challenges is to say, wait a second, slow down. Are you trying to suggest that these Nazis didn't realize that executing the Holocaust was against the law? Is that what we're going to try to suggest here? That they didn't realize what they were doing was against the law? That seems ridiculous, that they should be surprised that we're bringing them on trial on charges for breaking the law. Everything that the Nazis did was in violation of any notion of law, right? That's what the Nazi regime did. The Holocaust broke every principle of law, right? Furthermore, there are quotes, there is research that can be said where the Fuhrer, Adolf Hitler, and his subordinates clearly and openly said that they had no respect for standing laws, that they were making their own laws, that they felt like they were above the law. They said that in many different cases, right? They knew what they were doing was criminal. That's why they tried to hide it, right? That's why Adolf Hitler killed himself at the end of the war, and several of the other Nazis killed themselves at the end. They knew what they were doing was wrong. After all is said and done, should it surprise anybody that mass murder is a crime? That's what Robert Jackson is going to try to argue. When I think about that, though, then it starts me thinking a little bit, wait, doesn't that suggest that all war is criminal? Using these similar sorts of arguments? Doesn't that suggest that all war is criminal? I don't know. You all try to wrestle with that question. Not quite sure, but as a philosophical enterprise, that's a question that pops up into my head as I'm reading through Robert Jackson's arguments. By the way, Robert Jackson is going to suggest that there are actually precedents for these trials. In the first case, there was the Bryant-Kellogg Pact of 1928. And that pact was signed to by Germany, and it renounced war. War shall be renounced. The other treaty that Germany was party to were the Geneva Conventions of 1924. Those treaties suggested that war is an international crime, and that prisoners of war shall be treated in a certain manner. Germany clearly violated those. The actual constitution that Germany was living under, the Weimar Constitution, suggested that international law is accepted by Germany. Therefore, we shall try them for breaking international laws. However, Jackson is very astute in acknowledging and admitting that there's no specific precedents for these particular laws that they're being charged with. That is, crimes against peace, war crimes, and crimes against humanity. Jackson does acknowledge that, but he's trying to suggest that, look, there is a legal body of precedent here that does suggest that Germany is subject to these sorts of, these three key charges, and that these individual Nazis are subject to these three charges, right? And by the way, Jackson says, this is the best time for us to set the precedent of this international law. And that's why these trials in Nuremberg in 1945 are so important, because we are setting the precedent. And of course, these have been attempted since then as well, right, after 1945. By the way, Jackson does leave us with a few remarks. By the way, international law isn't implemented in the same way as domestic law. And that's why we should be allowed to do this. Well, what does that mean? In domestic law, in a democratic society, we, the people, make our own laws. But in international law, the people and the parties to international law don't always agree. And that's what's a little bit quirky for some people, certainly for Wizanski, but even later, certain Taliban troops and certain dictators around the world have suggested, wait a second, I didn't agree to any international law. Why should I be subject to international law? That kind of reminds us that question, what is law? Well, law is this sort of thing that in the domestic realm, at least, is something that we shall all agree to. I, for example, agree that there should be a law against first-degree murder and second-degree murder and third-degree murder and all the rest of those things, right? As part of a democracy. But the fact of the matter is, since there isn't an international government, this means that the rules won't exactly be applied in the same way. And that's going to be something that Jackson acknowledges, but he says that shouldn't be a problem to us, right? We still need to have international law. And, by the way, as a wrap-up, this whole tribunal, these Nuremberg trials in 1945, are about restoring this thing called rule of law. Rule of law is what we're trying to do here. So, that, with all those ideas in mind, we shall be justified in holding these Nuremberg trials and prosecuting these individuals for breaking these three new laws: crimes against peace, war crimes, and crimes against humanity. What do you think about some of those challenges? Is Jackson giving us a convincing argument? Yes or no? Well, you've already heard a couple of my questions about that. And next time we'll see what Charles Wizanski has to say about the Nuremberg trials. Until then, see you later. Bye-bye.